Yes, Miss Wakeman, you were dealing, I think, with prejudice.
Yes, my lord. I'd reached the end of my prejudice part of my submission, so I just have one final point to conclude.
Yeah.
That just relates to promptness, and it's just to note that promptness is of course a freestanding condition for obtaining permission in CPR, Part 54.5.
Yeah.
So the test for those purposes isn't whether the department can demonstrate prejudice; it's merely whether the appellants have acted promptly.
Yeah.
My lords, you have my submissions as to that point. So unless I can assist further, those are my submissions on delay.
Thank you very much. Nothing from me. Thank you very much, Miss Wakeman. That's very helpful. Yes.
My lord, I had a reference for you.
Oh, yes. Thank you very much. Let me find the right place in the notes. Yeah, crack on.
The relevant clauses of the self-remediation terms are 20.3 and 21.2 on pages 59 and 60 of the additional bundle.
So those are the clauses that
provide that all civil
complete the promise that those will be in the full
Yes.
form documentation, and that's what they are. Yeah, thank you very much. Yes. Yes, Mr. Barker.
My Lord, first of all, may I thank the Court for granting to permission to have lay representation. My Lord, I'm going to be brief on address the Court on 4 points, if I may. First of all, overarching point which threads through both ground 1 and ground 2. Secondly, ground 1, the legality. Thirdly, ground 2, the procedural propriety or fairness of the delay. But may I also, first, just before I begin on those points, pick up on an observation of the Lord Justice Stuart-Smith earlier on, who I think said that he was under the impression that works had finished at one site. That should have happened at Jupiter 2, and that was in our evidence. Paragraph 34 of the witness statement for Jupiter 2. In fact, it's going to be March 25 of the evidence. Thank you. Thank you very much.
March 25.
March 25 the earliest, hopefully June 25 at the latest.
But you're well stuck, I mean, the building works are well stuck in.
They're well stuck in. I know this is me certainly giving evidence, but on the May certification is £10 million minus £500,000 retention. So
Yeah.
the total contract
Well
is
stuck.
well stuck.
Thank you.
So, my Lord, starting if I may with the overarching or general submission, and it's this, it is that the fundamental premise of the judicial review proceedings, or the hook on which the appellants hang these proceedings, actually doesn't exist. Take your lordships to what they say it is. There are 3 places where they identify the hook. First of all, it's in an email of the 16th of June 2022, which is in the supplemental bundle at page 96.
That's the exhaustion email.
My Lord, it is exactly that.
Yeah.
It is exactly
We are familiar with the papers.
Thank you, my Lord. Then
So just give us the references.
I
So
shall-
16th of June.
22, which
Yeah.
is the exhaust all other avenues of funding.
Yeah.
The letter from the solicitors of the 22nd of August.
Yeah.
And the point about that is they say, in those circumstances, and the circumstances are the insurer has sent a letter to Hemisphere accepting liability. The claim for funding from the Building Society Fund cannot be accepted and should be rejected if it's not full. And then they say the same applies to Jupiter 2 on the premise that Jupiter 2, the insurers will cover Jupiter 2. So they say at this point, because it's ongoing, it should be rejected if it's not full.
Yeah.
And then the third point is the in the the 19th of October 2022 pre-action letter, where they say, the solicitors again say, it's page 197 in the supplemental bundle. It is clear from the department's guidance, of the original one and the current one, the Building Society, the Building Safety Fund is to meet the cost of remediation to address the life safety risks associated with cladding. Then they go on, once all reasonable steps have been taken to recover such costs, in particular insurers under the applicable policies, i.e. only once such steps have proven unsuccessful. So they say exhaust all other reject while there's an ongoing claim, and you can only proceed if the insurance is proven unsuccessful. Well, there is nothing about exhaustion or proving unsuccessful or having to reject applications pending insurance claims being decided one way or another in the legal safety fund, either in the original guidance of 2020-2021 or in the updated guidance.
Just on that,
yes.
I've been noting up the guidance which is in the supplemental bundle at tab 2, starting at page 22,
Yes.
which says July 2020, updated July 2022. Is that a safe? Were there any material changes between the two?
There is one material change, Lord, and it is what is the technical requirement that applies, i.e. what is the basis of the fund grant to Jupiter 2 as an applicant, and it isn't the same at all. My Lord, if your Lordship has it'll be under eligibility. What the fund was for Jupiter 2 was to cover non-ACN cladding. And what the fund is for under the revised version is life critical fire safety risks, and they introduce a British standard. And what the July 2022 it's page.
Well, it doesn't sound as if that's a material change for what we have to consider. It
No,
may be
not for what your Lordships have to consider.
it's a material change. You say it's a material change for the funding for, because there may be a difference between the two buildings and the two managed, therefore the interests of the two interested parties. But for our purpose, so there's a.
For your purposes, no, but that is the only
Okay,
material difference.
I understand that.
Otherwise, the wording is not identical but similar.
Fine.
So, my Lord.
So anyway, your submission is there's nothing in the BSF guidance
No,
that makes good those
And
points.
if I may, I'll pick up on the point that Mr. Richards did. He referred your Lordships in the 2022 guidance to page 37.
Yes.
And the fourth paragraph
Where you do successfully.
provided.
Yeah.
Where you do successfully recover damages, exactly that paragraph.
Yeah.
And it's the fourth line down, provided through the fund. So what they're anticipating is after the fund has provided, actually has provided money, then if you do recover later, you have to pay it back. So that is completely incompatible with the proposition that you must exhaust all avenues beforehand, or you cannot make a grant while there is a pending insurance application. That can't be right. So that's the overarching submission.
Yeah.
Turning then to illegality, there are essentially two strands to illegality: non-compliance with the building safety fund guidance and/or fails to take account acceptance of fire covered by the insurers. Well, I've answered the first point: non-compliance with the building safety guidance just now in general overarching submission. As to failing to take account of the prior acceptance of cover, they did take account. They expressly took account. Your Lordships have seen that in the emails. They took account of the fact that Hemisphere had been accepted for liability cover, and they took account of the fact that Jupiter 2 was likely to be accepted for cover. So your Lordships have been referred to the email of the 8th of June again. That's supplementary bundle page 83. Another email at page 80, the 4th of July. Mr. Richards referred your Lordships to that. Hemisphere and Jupiter 2 as a heading. We've noted your comments on the insurance claims for these buildings. Having assessed the available evidence, the department and its delivery partner do not agree that claims is available to fund the remediation of these buildings and allow works to start on their expected start dates. So it's the same point. Well, there is then a supplementary point on illegality, which is this: paragraph 38 of the Appellants skeleton argument. Redrow submit that BSF guidance does not permit speed emergency to be taken into account as an overriding consideration, and they submit that Mr. Justice Garnham erred in so doing. In other words, in my submission, that is completely wrong. The passages in his judgment that relied on it are in the core one of pages 6 and 7, and then paragraphs 22, 23, and 25.
Yeah.
My lords, if your lordships would look at the supplemental Bible, the Building Safety Fund guidance starts under tab 2 on page 2. Page 26, it's in the introduction. Second paragraph of the introduction, page 26 of the supplemental bundle. The fund is part of the wider building safety program, whose objectives to ensure that residents of high-rise buildings are safe and feel safe in their homes now and in the future. And then your lordships have been referred to the fund objectives over the page on page 27, where the first one refers to quick and proportionate resolution.
Yeah, well, we've got that.
You've got that. And it's driving the pace of remediation on page 30 as well.
Yeah.
So right through the Building Safety Fund guidance, speed of remediation for obvious reasons is stressed. So when you come to look at all reasonable steps, which is what the applicants focus on, the all reasonable steps has to be looked at in the context of the BSF guidance itself. It isn't all reasonable steps that determine how you look at whether all reasonable steps have been taken or not. It is in the context of speed being important. Have all reasonable steps been taken? In my submission, they were, and they were rightly recognised as having been taken. So the appellants are wrong, and it's a misconceived submission to complain of the approach that Mr. Justice Garnham took in the interpretation.
It's the word reasonable that's qualified by the need for speed.
Exactly. Well, and it's all in the context of the speed that is the overriding principle of executing the scheme. So everything you can do reasonably.
Yes, you've got 2 points. One, it's not all steps.
No, it's not.
And two, the context for all reasonable steps is speed.
Exactly.
And I was just suggesting that what it is actually qualifying is what is meant by reasonable. Because what's reasonable in the context of the requirement.
Of speed.
All right, is that it on illegality?
That's it on illegality.
Yeah.
So on procedural impropriety and on fairness, there are 3 points. The first one is that there was a failure to identify reasons for the decision. And as to that, your Lordships have already seen the email correspondence. The reasons were given in advance. The decision really confirmed what was already not just on the cards, but in evidence. Second ground on procedural impropriety is rejecting the applicant's position in their letter of the 22nd of August. Well, that letter, without going to it again, does nothing more than repeat what has already been said and exchanged in the correspondence. And it's an attempt to put in a lawyer's letter the exhaust point. Well, the exhaust point is wrong. And then the third point, the second main ground under procedural impropriety and unfairness, is that there was a failure to give the applicants adequate opportunity to participate in the process. Again, your Lordships have seen that whether or not they were entitled to participate, in fact they did, and they were listened to, and their views were taken into account. But they simply weren't agreed with. That's what the complaint really is. It is that outcome, one way or the other, of an insurance claim, then at every stage where the application is progressed, there is a decision which is unlawful, because they should not keep progressing the application. What they should do, what the department should have done, if they were right, is say, we can't entertain this any further, come back to us when you had a result from the insurer. But that, one would fly in the face of the timetable set in the DSF guidance for the making of applications, because there's a very strict series of timetables. And two, it would also fly in the face of the very steps that Redrow urged Jupiter 2 to undertake back in January 2021, which was to make both a BSF application and, through the leaseholders, claims under the insurance policy. So really what they're trying to do is applicate and reprobate. They're trying to, what's how they take me to, but having pointed us in that direction, they're now saying, well, everybody's wrong to have done that, and the whole thing should be torn up. Well, that kicks the clock off much earlier than the 22nd of August 2022, because your lordships have seen correspondence in June 22 where the department has made claim that it is going to proceed with the application and keep considering that, notwithstanding that insurance is either unresolved or resolved in favour of liability being awarded. And if that's right, and if the time limit is 3 months, the latest start date is the 8th of June 2022. Because that's the point on which Redrow said you must stop. And 3 months from there, of course, September 2022, never mind November 2022. So if they're right about it being wrong to entertain both the BSF application and an insurance claim, what should have happened is that they should have taken the, although not expressed as a decision, the implicit decision of the department to, by conduct, to keep processing the application and to tell them to keep processing the application as the kick-off for time for judicial review. So, in my submission, time has long expired. If that's the right approach.
Yep, thank you very much.
That's it on delay.
Thank you very much, Mr. Walker. Yes, Mr. Singer.
Lord, subject of course to any questions, I don't anticipate being more than about 10 or 15 minutes.
Right, that's good. It's noticeably warmer in here than it was this morning.
I was about to.
So I take with both hands the gift of 10 to 15 minutes.
Yes, I did notice when we came back in from outside that it had not got any cooler in.
No.
Look, can I start on standing if
Yeah,
necessary?
yeah.
Well, when this decision was taken, as your lordship pointed out in argument, there was no private law remedy. Because of the carve-out, there is still no private law remedy. When the decision was taken, in terms, and this is page 160, the department said in terms that they expect Redrow to reimburse for all funds paid out under the terms of the GFA, and that was, of course, in August, and there wasn't a contract until March, so that must have been an expectation to repay then.
Yeah.
So it seems to us, with respect, that Redrow must have standing to challenge that decision, and the fact that the parties have carved out the contract for the purposes of, as it turns out today, because proceedings are continuing as of today, means that it can only be a public law decision which was taken, and it could only therefore be a public law remedy that could be provided. And since there is a clear potential liability which the department are themselves still, we understand it, pursuing for a repayment of what must now be regarded probably as the minimum of £30 million, how can it actually be said that Redrow does not have a sufficient interest in the decision to challenge it? So, my Lord, those are my brief submissions on standing,
Yep.
unless there's anything else I can say on that. Delay. My learned friend did, I think, submit that because Mr. Justice Garnham didn't say anything about delay, that somehow meant that the court was only really reviewing Mr. Justice Ayres' decision on the papers, and therefore well, two things. First of all, it therefore had more of a free hand to review, and secondly, it could do so as it were almost afresh. I respectfully disagree with that analysis. The respondent, although not called on, was in attendance, as was the interested party, Mr. Justice Garnham. The grounds which of summary resistance had not been amended between Mr. Justice Ayres' decision on the paper and the hearing of Mr. Justice Garnham. And it must be, if not implicit, if not explicit, certainly implicit in Mr. Justice Garnham's decision that he did not disagree with what Mr. Justice Ayres said about delay. And in those circumstances, we actually submit that Mr. Justice Garnham's judgment did encompass the issue of delay. And therefore, you, as the appeal court, should take it that you are reviewing the decision of the judge's delay, which we respectfully submit is a discretionary decision, which should only be overruled if there are principal reasons for doing so. In addition, we do respectfully rely on the fact that we were entitled to wait for the substantive response which was promised shortly. And the suggestion that, the suggestion was almost made was, well, there's no point waiting because you knew what we were going to say, is illustrative but not dispersive in our respectful submission. And of course, the other thing is this: if you do wait for reasons and they don't arrive, that of itself gives you a reason to challenge the decision. So you're damned if you do, and you're damned if you don't. Well, that's in fact what happened here. We did wait, and once the decisions were clear, the reasons were clearly not coming, then a pre-action protocol letter was sent. So what else, one asks, acting promptly, could an applicant do? But I suppose the only thing it could have done was served a pre-action protocol letter earlier. Well, would that, we would have to wait a few weeks at the very least before doing that. And so is it said that literally the want of a few weeks of an earlier letter that this is not a prompt application? We say it can't be, and of course you know that there's some delay after the letter of the 19th of October, not least because the department needed some more time to respond.
Yes, but to be fair, Ms. Wakeman was very careful to in her key dates to end on the 19th of October. So your first submission, it goes to her point that the letter should have been earlier.
Yeah.
But as I understood the submission, there was no criticism of the position afterwards. I think it's a very fair way of putting the delay case.
Lord, I'm grateful, and I apologise for not picking up on that.
Yeah.
But nevertheless, we say that a delay from a decision on the 26th of August to a pre-action protocol letter of claim on the 19th of October, it doesn't, in the circumstances where a substantive response is promised shortly, is not a lack of promptness.
No.
So unless I can say any more on delay, well, I don't need to say any more on the overarching principal point in Mr. Justice Ayres' judgment taken up by Mr. Justice Garnham, because it, as you had anticipated, my learned friend, quite properly, this doesn't support it. Though we, of course, your lordships are looking at this and deciding if there are arguable grounds. If you are deciding if there are arguable grounds to challenge, as a matter of an appeal against Mr. Justice Garnham's decisions, I do still make the point, with respect, that both of those decisions are clearly driven.
Well, you made that submission this morning, so we understand. We have that.
And well, then we get to the grounds that we make. First of all, in respect of ground one, unlawfulness. We, again, I apologise because I have made this submission before, but we do say that you, particularly in a case where it is accepted that the real issue is whether the guidance was complied with or not, or whether it applies at all. So on the basis that the guidance needed to be complied with, we do say that in the context of an acceptance of cover and no indication as between the insurer and the insured of any problem in August 22 with payment of the cover, then the responsible entity is not, as at August, unable to fund the works.
We're not able to what?
Fund the works. And we, of course, I accept that, again, that I can't answer my Lord Stuart-Smith's point made this morning, that when might those funds have become available, what sort of extra time might have been reasonable to allow before making a decision. I can't answer that question. I can't answer that question because as between Redrow and the insurer, I'm not privy to that information. I'm not privy to what was going on in the insurer in the background.
What do you say about the building where cover hadn't been confirmed?
Well, we say there was no reason to doubt that it would be confirmed very quickly thereafter, as indeed it was. And the process was
supremely optimistic approach.
Well,
given the dates that we're dealing with.
Well, Lord, I hope you'll forgive me for being, as ever,
for being optimistic.
Oh.
Of course, forgive me for being optimistic. I just said supremely optimistic.
Well, that as well. But the reality is that there was an ongoing claim with those insurers. And my learned friend, I think, at one stage before lunch, suggested that all reasonable steps, which is what the guidance said, not just reasonable, all reasonable steps, it is complied with by making a claim on the insurers. And in my respect, that can't possibly be right in a case that you don't simply get over that hurdle by putting the claim forward. You've got to do more than that. It's obviously going to be a process which is going to involve a considerable amount of to and fro with the insurers. And obviously, when writing the guidance, the government's going to know that because they because everybody knows that, and also because they lump that in with legal action. Well, one assumes it couldn't be said that taking all reasonable steps through legal action would be, for example, sending a pre-action protocol letter of claim and then saying to the government, well, we've taken a pre-action protocol, wait for the response which says we're not paying. They always do. That can't possibly be all reasonable steps either. And that leads into the next point, which is that clearly the decision is being justified now and was justified in the courts below on the basis of speed. That speed was everything. But clearly speed is not everything under the guidance, because if speed was everything, you wouldn't have to take all steps first. And again, pick up on a point that Lord Justice Dingemans made this morning, which is that you can't conflate the recovery of damages part of the guidance with recovering monies under their insurer, because that's a completely different thing. So we say that it isn't that speed conquers all. Speed might be our reason, amongst other reasons, but we don't challenge the decision now on the basis of unreasonableness or irrationality. Challenge it on the basis of unlawfulness. To say that speed conquers all is, in our respectful submission, to conflate those two different arguments. The question for ground one is was the guidance arguably, at this stage, arguably complied but not complied with? And we say that it arguably was not. On ground 2, there are reasons. The argument now it seems to be that no reasons were required because, in effect, they had already been given. There are 2 points on that. The first point, which I hope is not just a forensic point, is that if that was the position, the letter, the decision of the 26th of August would have said, would not have said the department has noted the contents and will respond substantively shortly. It would have said, we've already told you why we are going to do this. And it didn't.
That's a bit of a forensic point, because the flip side of that may be, well, we didn't bother sending one having looked at it because we realised we had.
Well, except they don't say that.
No.
My lord. And in their pre-action protocol, first of all, they said we're not going to give you any more cases, but we have given you some, just to help you along a bit.
When you were making your submissions this morning, I said, isn't there something about taking everything into account? And you rightly said, no, there isn't. But what I was thinking was, in the circumstances, which to my way of reading is referring back to everything, effectively everything that's gone before. In the circumstances, which have been discussed.
In the circumstances might, on a reading of the letter, mean that, but it doesn't incorporate your previous reasons simply by saying in the circumstances, especially when that's the second paragraph of the letter. And the first paragraph of the letter is we're going to give you our substantive reasons later. But my lord, also, the point, which I think may have been
You said there were 2 points. Is this the second one? You said there were 2 points. The first was, if that was the answer, the decision letter would have said it.
Yes.
Is this now the second point, or is it related to the first?
Okay, now I'm coming on to the second point.
Yeah. My pedantic note-taking. Council say there are 3 points, and then they say fourthly. Second point.
This is not an appropriate place to bring in a reference to once great television programme, The Number of Reasons, much as I would like to do that. Sorry, Lord. On the 11th of August 2022, and you've got the reference to that many times, 143. It is clear, we say, that the question of whether there was to be a grant at all was still to be decided. Otherwise, you wouldn't have said in the event the grant decided to go ahead. There is then the letter from McFarland, page 175, 22nd of August, which raises points about the consistency of the approach which has been adopted into paragraph 7 and following, consistency with the principles of the pledge letter, paragraph 11, and the solution, paragraph 13, and then observations about duplicative, paragraphs 15 to 16, reservation of rights at 17. Now, well, in our respectful submission, those points were not all, if at all, dealt with in the previous correspondence between the parties. Nor could they have been, as a matter of chronology, apart from anything else. There's no answer, for example, to paragraph 12. There's no, where it says there's no reason why the insurer should not comply with its obligation to fund and make a claim against Redrow to cover those if it wants to. That wasn't previously dealt with by the department. So it may be that there was a good deal of toing and froing before the decision was taken on the 26th of August, but to suggest that all the objections that were put forward by McFarland in their letter on the 22nd of August had already been dealt with, so see reasons before, is, in our respectful submission, simply wrong. And that's why you can't say, well, in the circumstances, means we've dealt with everything. Because A, they haven't, and B, they couldn't. And therefore, we say that you do need to look at that letter on its own merit and say, well, what reasons are then given? And of course, there are none. Lords, unless I can assist you any further.
No, thank you very much, Mr. Singer. Right, well, thank you all very much. Thank you all for your submissions. I am aware that the Building Safety Fund is a relatively new creature, which was part of my thinking for giving permission to appeal. It's important, so you will be unsurprised to learn that we will reserve our judgments in relation to this case. We've been greatly assisted by all of you and all of those that sit behind you. Thank you very much. We will provide a copy of our judgments in draft in the usual way. That's an opportunity for you to check the typos and any basic factual matters, but it is obviously not an opportunity to re-argue the case. The responses will then be taken into account in the production of the final version of the judgment, and that will be handed down. There won't be a hearing for the hand down, it'll be handed down remotely. We hope that you'll be able to agree all of the outstanding matters at the same time as commenting on the typos. If, for whatever reason, you can't reach agreement on everything for the order, then we ask you to draft an order, and if there are matters that you can't agree, that you provide extremely short written submissions on those points. But the aim is always to try and get the order done at the same time or very, very shortly after the hand down of the final judgment. And finally, as I'm sure you all know, but I have to remind you, the draft judgment is exactly that, a draft. We have the list of people to whom it is to be sent. It won't be sent to anybody else, and all those people are subject to the embargo. And as you are aware, it is contempt of court if any part of the draft is leaked before the hand down. Thank you all very much.